My name is Roger Citron. I am an associate dean at Toro Law Center. This is a Toro Law Review podcast. And today we have as our guest one of a United States Magistrate Judge, James M. Wicks. Judge Wicks has been a friend of the school quite literally for decades. I met him very early on when I began teaching at Toro back in the 2000s. Judge Wicks, thank you for joining us.
Oh, you're welcome. Thank you for having me.
And today we really are going to talk about you and what you do as a federal magistrate judge to help put things in context. Can you please just tell us a little bit about yourself, and then we'll walk up to being the job that you have now.
All right. Well, I was appointed, Roger, a little over 2 years ago, April of 21, during the pandemic. Before that, I had been a partner at Farrell Fritz for about 25 years. Metro New York, Long Island based law firm of about 80 to 100 lawyers at any given time. My practice there was principally commercial and business litigation, but I also had an emphasis on attorney professionalism, legal malpractice issues as well, grievance, things like that. And I was also the general counsel of the firm, I'd say my last 6 years there. Before that, I was at White and Case in Manhattan for a number of years as an associate. And before that, I clerked in this courthouse, well, actually in the Eastern District, the Long Island Courthouse. This one wasn't here, but it was in Uniondale. I clerked for Arthur Spatt, the district judge here. And as it turns out, years later, when I was appointed, Judge Spatt had passed a few years ago. They had assigned his courtroom and chambers to me. So I now sit in the chambers and courtroom that he occupied when I was one of his first federal law clerks. So I still have some of the furniture in there, and that's pretty good. But I also am an adjunct professor, Roger, at St. John's. I've been doing that for about 15 years, teaching 2 classes, pretrial advocacy, as well as a deposition practice, sort of a 2-week workshop. I do that in the intersessions. And unrelated to all that, I'm a captain in my volunteer fire department. How's that?
You really touched all the bases. And where's your volunteer fire department? Which town?
I'd rather not say public.
Oh, okay.
Security reasons. The marshals would probably kill me if I did. But it's a suburban. It is a suburban volunteer fire department.
Yeah. No, I should have thought of that before I asked the question.
That's all right. That's okay. Please don't ever hesitate.
Part of what's wonderful is the continuity coming full circle.
Yeah.
It's a great story.
Well, and I even, when I was appointed here, Roger, I had a portrait hung in my courtroom, which was his courtroom, and I view it as always his courtroom. So it's pretty nice. Every morning I step on the bench, I look at him in the portrait, and in all sincerity, it guides me.
Uh-huh. And one, I'll say it this way.
Mm-hmm.
I clerked for a judge, a United States District Court judge,
Yep.
way back when. And this slightly takes out of context what he said, but it's sort of relevant to the question I'm going to ask, because I was very interested in being a government attorney. And he said something like, well, why would you do that? Because you can already get into a really good law firm. You don't need to do the government job. And so the flip for you is you were a very successful lawyer in private practice. I mean, the general counsel position speaks to, we're truly how you were seen by your peers and partners at the firm. Why did you become a magistrate judge?
Well, I appreciate that. But I like you just said, Roger, your judge that you clerk for has an influence on you. At least it did on me. And he was always encouraging us law clerks throughout his career, he was 30-something years on the bench, to consider becoming a judge. And watching him and how much he loved being a judge and the good he did, it definitely instilled from a very early time in my career that I someday want to be a judge. Now, since then, he's had 3 of us become judges, Judge Tomlinson, myself, and Judge Locke.
Uh-huh.
we've all were Judge Spatt clerks, and I think all of us listened to him, and I know it's gonna sound corny, but I actually view it as a calling. I did when I saw him as a judge, and I felt I needed to do it. I wanted to do it, and then the timing is always an issue. You know, I was in private practice for a lot of years. I had kids that I raised, my wife and I raised and got through college. So the timing was right for me. They had finished college and they're on to successful careers, and financially it was able to make the decision a little bit easier for me and my wife to allow me to do this. So, and she's been completely supportive of me doing it, but it's something I've always wanted to do.
Yeah. Did we really will come back to Judge Spatt, I think, when we
Yeah.
talk a little bit more about day in and day out what you do and how you do it. But one of the things that I truly find interesting, and because I teach public law subjects,
Yeah.
especially like, that involve cases litigated in the federal courts,
Right.
you're not an Article 3 judge. You're not an Article 3 judge. You're an Article 1 judge. And what's the process for becoming appointed as an Article 1 magistrate judge?
Yeah, that's a good point. Good question. So the Federal Magistrate Act of 1968 is what created the position. And what it did was it created a national position of non-Article 3 judicial officers to help assist the district court. And that role has grown. Originally, they were simply called magistrates. In 1990, a law was passed creating a title magistrate judge. It's the responsibilities have increased dramatically. But how do you become one here? So each district has its own application process, but they generally are the same in each of the districts. I say generally because Eastern District, for example, their application is much longer than some of the sister districts. It's a 16-page application. I think, gee, it's not so bad, although each question is bad. It's list every case you worked on in the last 5 years, list every appeal you've argued in the last 5 years, list all of your adversaries, list, blah, blah, blah. So it goes on and on. It's a pretty extensive application. So anyway, they open up a spot. There's a spot open. And again, I speak for the Eastern. You apply, and there may be at any given time, it could be hundreds of applicants. It could be less, could be more, depending on sometimes there are a couple of openings. And it's an 8-year term, by the way. That's how long the term is for magistrate judge. Bankruptcy judges are 14 years, magistrate judge 8 years, and you could get recertified. So you make the application. There is in every court a magistrate judge merit selection panel. And in this court, I think it's about 20 individuals made up of not court personnel, but people outside of the bar, educators, lawyers in the community, and non-lawyers, specifically non-lawyers as well, people in the business community. And they go through the applications, winnow it down to a number, and then they assign different people in that group. From what I understand, I have not been on that committee, but from what I understand, they assign somebody to sort of do the vetting of a particular candidate. So that person will then call references. It can range from adversaries, to judges you've appeared before, to people at your work, to neighbors, things like that. They report back to the committee. The committee then votes on, again, they pick a smaller number, then maybe it's 3 to 5 that they submit to the full board of judges, the Eastern District. Then the full board of judges goes through and decides who they want to interview. And they interview us or applicants at, it's a one interview with the 26 judges or wherever many there were at the time. When I applied, it was during the pandemic, so it was a Zoom interview. And I think virtually everybody, all the sitting judges, including some of the senior ones, were on the Zoom, and they just fire questions at you. You go through that process. Once they select someone, then it's in the hands of the FBI. They turn everything over to the FBI, and then that's about a 6-month process. And that, I mean, that truly, in my case, I know the agent spoke to about 55 people. And again, ranging from neighbors to people I went to school with years ago, to adversaries, to judges, and it's sort of the big range. And once you get through the FBI background search and investigation, once you get clearance there, then you get appointed. So it's a process. It takes a while, but it's, Judge Spatt used to say it's the only true merit selection process for a judge in this country. And I used to laugh at that, but there is something to that, because it goes through, there aren't politics involved. It's truly, they're delving into you as a person and as a lawyer.
Yeah, that's what I found fascinating. I think perhaps when I was a law clerk, I just must have heard people talking about in Philadelphia, right, the Eastern District of Pennsylvania,
Yep.
an analogous process. And it is extremely thorough. And and I mean, I say this not to diminish anyone. It wasn't just because they knew Arlen Specter, which was, of course, in the late 80s and early 90s.
There is something to that. And when you think of the makeup of the selection panel itself, you have people like yourself in academia, you've got lawyers, you've got people from the business community. It's a real mix of people and views, and they really are trying to get the best of the best in their view for the seat. So it's pretty refreshing, actually, having gone through it and passed through it. But
how can I just curious, from say that about the time when you completed the 16-page questionnaire, and then until you were actually, I guess, confirmed. So was that 2 years, a year and a half?
Well, and the pandemic throws things off too.
Yeah.
The FBI agent had a difficult time, arranging in-person interview. Like, it was a little bit difficult for him. I know that. So that took a little bit longer than usual. But I would say, let's see, I applied summer, I think, of 20. I got a call in the fall that I was selected for the committee. The committee wanted to, interview me. And so I knew I was in committee in the fall of 20. And then I didn't really hear anything. Honestly, I think it was until toward the end of the year. Then I get a phone call that you're now going to get an interview with the full board of judges. So I made that level. And then I got, I don't know, it was a few weeks before I got sworn in. So I'm guessing sometime in March of 21. So it was probably, not quite a year, 10 months, maybe, the whole process for me, something like that, which isn't bad, but it is.
I would have taken the over. I would have absolutely taken the over. At least a year, I would have thought.
Sometimes it does take that long. And when I applied, Roger, there were actually 4 slots open at the same time. You had different, due to retirements, people leaving. 3 in Brooklyn, 1 out here, and so we were all going through the process at the same time. Everybody had a different agent apply, that was assigned to them, and so they were doing it all at once. So I was surprised, actually, how quick it did take ultimately, given all that.
And then you had sort of adverted to this when you were describing the history of the legislation. With respect to magistrate judges and so on. What do you do? And that's you have both criminal and civil responsibilities, as I understand it.
So, and that question, Roger, you could ask magistrate judges in different districts, and you'd get 50 different answers, or more, because there's different districts even within the states. But here in the Eastern District, it's a very fulsome position, in the sense that, when a case is filed here, you are assigned a magistrate judge and a district judge right out of the gate. So you'll see initials for both a DJ and an MJ right on the complaint. And that means that when I get assigned the case on the civil side, it's for all pretrial non-dispositive matters. So first thing I do is set up an initial scheduling conference, and then I manage discovery, deal with just any discovery motions, any non-dispositive motions, motions to withdraw, things like really everything leading up to dispositives. If they consent to me for all purposes, it becomes mine like a DJ's, and I try the case. If they don't, I take it all the way up to the point of the joint pretrial order, make sure it is in order with or in line with the way that the district judge is trying the case, likes their pretrial orders, because we all like them different. And once I think everything's in order, I then turn it back over to the DJ and I have nothing to do with it. So it's really soup to nuts. And when you think about it, Roger, 97% of civil cases settle. That means I have it for, most cases for their life. And all along that, you're also in every case, I at some point along the way do a settlement conference for sure. And, as I say, because the settlement rate is so high of civil cases generally all over the place, we're in line with that as well. So criminal side, you divide them up into sort of petty offenses or misdemeanors and felony. Petty offenses, misdemeanors, mine for all purpose. One of the first cases I got when I got on the bench involved hoarding of masks when the pandemic hit. And somebody purchased masks in China and resold them after a severe markup. And they were charged with and ultimately pled guilty to violating the hoarding statute. So those I handle soup to nuts, including sentencing. On felony, I do all pretrial things like arraignment. When they get arrested, I issue arrest warrants. I do search warrants. So the FBI or any other agency might come in and, ask for search warrants and you review that. I do bail applications, detention hearings, motions. If there are discovery motions, we would handle those. Jury selections, grand jury hand-ups. When the grand jury hands up indictments, we review them and they issue out whatever warrants we have to issue. Grand jury selection. So there's a fair amount, and I think most courts do it this way. They assign a duty magistrate for criminal duty, each week. So I get it every several weeks. Some tag them in, so you never know what comes up, or who they arrest, or what warrants have to be issued, and they just come in that day. You just don't know.
And that's kind of like really like a doctor being on call.
That's exactly like it. There's a doctor in an ER. Right, it's exactly it. But even apart from that, Roger, I have the privilege of presiding over naturalization ceremonies. Swearing in new citizens. I did one today, and without fail, it brings a tear to my eye every time. Just the reaction of the people, the families, and some of these people wait 25, 30 years to become citizens, and it's a remarkable ceremony. If for those who have not seen one, it's 20-minute ceremony, half-hour ceremony. It is absolutely worth seeing a ceremony, because all of us come from immigrants ultimately, right? So that's worthwhile. And the other thing I really like doing, that I have the privilege of presiding over, are attorney admission ceremonies. So, just because someone's admitted, of course, in New York State, they still have to get admitted in the various federal courts. And if they, apply here and don't waive in here and go through the admission ceremony, it's always a nice ceremony. Usually it's a mother or a father who may be an attorney sponsoring them, or a brother or sister or something. And that's really, really enjoyable. It's a real positive thing. Plus I get to do weddings. I've done a couple of weddings already. So that's been fun. It's not a magistrate's act, but I'm empowered now to do it.
And then I wanted to go back on, so I don't know if this is the fact that it was a different district or a different era, but what I recall, I had really, in my experience, what I remember from being a law clerk, and again, this is a long time ago in the early 90s, but it was just one set of initials. This was in the Eastern District of Pennsylvania, and then it was kind of like, unofficially, well, every judge had his or her or their magistrate.
It's exactly how some districts do it still.
but it sounds like with you, is this correct? You could work, that is when it comes off the wheel or the assignment, it was called the wheel back then. You
Yeah,
could
yeah,
be,
yeah.
it could be any judge, any district court judge. Is that,
Yeah, so
or,
I am in the wheel. So I'm
mhm.
in the wheel with the other judges. Don't know who I'm going to get paired with. Could be a judge in Brooklyn, could be a judge here. And it's random selection. Now, if there are related cases, we might say, okay, Wicks, you were assigned to this one, but this other one is before Judge Shields, and it was a pre-existing case, and blah blah blah. So it would be transferred to her. She might have all the cases, that sort of thing. But yeah, it is random selection, and we are assigned. Our initials are on it, so we're right out of the gate. That's with the exception of there's a few judges here who just who don't do it that way. They've decided they just want to handle the cases themselves, and on an as needed basis use the magistrates. And that's frankly how most of the country works. We're sort of
Mhm.
unique. Eastern District's sort of unique that way.
Yeah.
Most of the
And
other districts, including Southern right next door, they're not assigned out of the gate, and it's sort of random assignments to the magistrate judges.
and I would imagine, I mean, really, you described a substantial set of responsibilities on both parts, that is civil
Yeah,
and criminal. But I would imagine that part of, I would, I should ask, but I would assume that part of what's enjoyable is because as you're, especially on the civil side, you must keep in touch with the district court judge to whom the case has been assigned,
it's funny. That's a good question.
or do you? I guess is the question.
I'm going to say it varies. I mean, remember the litigants. If I do an R&R, report and recommendation, they have the opportunity to object. It's essentially
Mhm.
appeal. They also have the opportunity to appeal any non-dispositive order that I issue. If I direct somebody to produce documents and they think I was wrong, they can appeal it to the DJ. So I don't talk to the DJ about those. I mean, they'll decide whether I was right or wrong. I feel like it's just like a DJ doesn't really talk to the appellate panel reviewing their decisions. I don't think personally, I don't think it's the right thing. And that's the beauty of this system that we do. It actually, I think lawyers should appreciate this. I never really appreciate as much as in practice until I've been on the bench, but really, it's almost like having interlocutory appeals. If you just have a DJ issuing discovery rulings, there's no appeal from that. If you have the MJ, they can appeal to the DJ on those. Almost like state court taking
Yes.
interlocutory appeals. And I never really thought about it until I was on the bench, but the system we have here allows litigants to really, challenge some interlocutory rulings that they otherwise wouldn't be able to.
Oh,
Yeah.
I'm filing this away for next semester when we get to discovery practice, because of course we also do the final judgment rule
Yeah. Well, that's
semester
it,
as
right?
well.
Yeah, and
And
you know
this
how
is,
different it is in state court, right? I mean, state court goes
yes,
to the appellate
yes.
division every time, documents have to be produced.
Um, and it's funny because I do remember that I absolutely do remember, sometimes reviewing the report and recommendation from the magistrate judge. I mean, back as a law
Yeah.
clerk when we were the district court judge,
Yep.
and my general impression was, and this is also true sort of in published decisions that I've read,
Yeah.
the R and R, the report and recommendation, they tend to be very thorough. Um,
Yeah.
uh, and I don't know if that's something that is just, it can't be just serendipity.
No,
But
here's why. Because
yes.
if I have okay, let's say a motion to dismiss or summary judgment sent down to me, and there are, four claims that are at issue or four arguments as to one claim, I have to address all of those, even if one of them, let's say it's pretty clear there's a statute of limitations that knocks this whole case out. I still have to go on to the others because in the event the DJ does not agree with on
Mhm.
review, I still have to give them the benefit of the doubt of my reasoning as to the others. So if you disagree above, at least that's the way I do it, and I speak for myself. I think on R&Rs, that's why they're particularly tough for magistrate judges. They do have to go through everything, even if it's pretty clear that there's one ground that might be the basis for dismissal. You don't really have to, how you've read some decisions that say, and the others, we don't
Yeah,
even
we
right.
need not address the other
We need not
the other
address
arguments
exactly.
in the brief.
Yeah, yeah. See, as a magistrate judge, I need to address. So just for the benefit of the DJ who's reviewing me, if
And
it's
then
in
I was
corner, it's different. I can do
yes,
that. That's different. Yeah.
yeah. In the and then on the criminal side, one thing I wanted to ask because
Yeah.
the fact that you have the misdemeanor, in other words,
Yeah.
it's if you will, that's your case, in its entirety. Um, I do, are there jury trials in misdemeanor cases?
Yeah.
And so in that case, you really have the whole piece, which would be
I have
you.
not had one yet. I have not seen too many misdemeanor prosecutions of late.
Uh-huh.
They're so bogged down with felony stuff. I think, to just overwhelm sometimes. But yeah, no, could be a jury. And as I say, we have it soup to nuts. Time it comes in from arraignment to sentencing.
Yeah.
Misdemeanors,
Uh,
yeah. They're just not that frequent though.
um, and the no, I'm, and it's funny when you said that you're you used a great adjective, fulsome, to describe your responsibilities.
Yeah,
Because we've had, at least one of my colleagues, I think at least, and perhaps two, but at least
yeah,
one clerk for a magistrate judge over in you know, uh, Central Islip, in the federal
yeah,
courthouse in Central Islip. And I was really, it, she was very, very busy. She was, and
yeah.
as the law clerk, which of course meant the magistrate judge was very busy. And part of me was slightly, well, why would that be true? Because,
Uh,
my experience
yeah, because
as a law clerk
we,
was that
yeah.
they have less responsibilities, but not really, it seems.
No, I mean, the way the system is now, honestly, the DJs have it for trial and dispositive motions. Otherwise, everything else is the MJ. Everything
Yeah.
from intake to scheduling to managing discovery disputes, settlement conferences. I mean, that falls in our lap on referred cases, which I love. It's all pretrial stuff. I mean, I teach the stuff, so I love it. But and listen, we're moving. I don't know if you saw it, but if you see the Eastern District website posted, I think this week was an administrative order announcing that there's going to be a pilot program, a 2-year pilot program on direct assignments to magistrate judges. So a certain number of cases now, you're only going to see MJ initials on it. Then there's a period of time for people to, opt to get a DJ assigned. So if they file,
Hmm.
for example, a dispositive motion, then they have to give the option: do you want a DJ assigned, or do you want to stick with Wicks? And
Yeah.
it's called the direct assignment. It's just coming out. It's going to be effective sometime in October, I think. So that's going to add a lot more, possibly consent cases to us.
Is that truly, really, is the Eastern
Yeah,
District the first to try and do it in this way, to
no,
do something like
actually,
this? So,
no. California courts have done it, and it has led to a dramatic increase in consents, which relieves the burden on the DJs. I say burden, and there is a burden because they have criminal felony cases that they have to try, and that takes up an awful lot of time for them. It's hard for them to then schedule with a reasonable degree of certainty trial dates for civil cases. So, but yeah, California has done it. I don't know for how long, Roger, but they've been doing it to the long enough that other districts are starting to look at it. The AO is suggesting that other districts look
hmm
at it because it's an effective use of magistrate judges. That's what they're looking to do: is how can we effectively use magistrate judges to assist in the administration of justice in the district courts.
Really, very,
Yeah,
very interesting. As a shorthand, when I teach civil procedure,
yeah,
there's a marvelous law review article by a Yale Law School professor, Judith Resnick,
good.
and she called Managerial Judging, is the name of the article. And while broadly, thematically, it's about on the civil side, that's really what judging is managing, right?
Yeah,
And it
that's it.
sounds like that falls on substantially on you, or
Yeah,
maybe even more than substantially.
yeah, it
Uh,
does. I mean, listen, we're referees. When it comes down to it, we are all, the judges, DJs, we are referees. We don't have a stake in the game. We're referees. That's, we're in effect bystanders, just making sure the rules are being played fairly.
mhm.
That's really it in a nutshell.
Yeah. Well, so I mean, just from the conversation we're having, you seem to enjoy being a magistrate
Are
judge.
you kidding? I love it.
Yeah, yeah.
I before this job, I would say my favorite job, my best job was being a law clerk for Judge Spatt. And I always
Mhm.
tell people it's the best job I had in my life, for a lot of reasons. And this has, I'm sorry, Judge Spatt, but I think this has this has superseded that. I think I'm truly enjoying this. Listen, I love working with the lawyers. I love working with litigants, pro se litigants. I mean, it's a rewarding feeling to see justice being done, even if it's in a settlement conference where you're helping people resolve disputes. I mean, it's just something about that. I love working with my law clerks. I change law clerks now every 18 months, and I have two law clerks, and they
Mhm.
overlap. And I love the relationship that I develop with them. And to me, they're lifelong relationships, and I love trying to keep them together, the law clerks, as a group. And so we socialize a couple of times a year, dinners, things with old, past clerks, and I'm going to continue that tradition, as Judge Spatt did. And I've got very tight bonds with my, people that were Judge Spatt clerks, 10 years after me. So, and I want to continue that. I love the student interns we have that we take, and we take some from your school, which I've told you before, excellent. And I enjoy that. I enjoy seeing them observe good lawyering, bad lawyering. And like after we'll have oral arguments here, for example, I'll take the law clerks and the interns will all sit around my table and talk about what was good, what was bad, what would you do differently if you were this lawyer? Why do you think they made this argument? I think it's important for them to see what are the judges thinking. So when they're out in practice, they know what to deal with. But I just, it's funny. I love. It's it's an awesome responsibility, right? Resolving disputes, and I don't care if it's a fight over interrogatories or a summary judgment motion. I mean, you're resolving disputes, and I truly view it as an awesome responsibility in the sense of it's big. It's a big responsibility. I take it seriously. It's a lot of power, and I pray daily that I stay within in the guideposts and do things right and don't play favorites. And I mean, these are things I all think about now as a judge. It's very, very important that everybody that walks away, whether it be in an oral argument, a trial, a conference, that they feel like they were treated fairly. That's all. They may lose, but they were treated fairly. That's my goal when I sit here.
Yeah, yeah. The I'm going to tell the story now,
Yeah, yeah,
only because so my judge died several years ago,
mhm,
and he had a long tenure on the bench, including a number of years as a senior judge,
yeah.
and he had at the time, at least he may have actually at some point very near the end sort of even stepped down as senior, but at the funeral, a number of clerks spoke. And the last one was the permanent clerk who said, and I remember saying to her afterwards, you completely nailed it, which was,
Oh,
it's not that there was one case that defined who he was or that he did. She goes, I would say the way he treated pro se litigants. She goes, that's what I think of with the judge. And
yeah,
I thought, because he was patient and
yeah.
he said, I remember him coming off the bench one point and saying, I'm going to rule against this person, but they have to feel like they were heard
That's it.
and taken seriously. And it just,
That's
when
it.
it really nailed, I think,
Yeah,
like the core, the
that's
essence.
that's pretty powerful stuff. And
Yeah.
judge sounds great. I mean
Uh,
that is the essence of it, though. And sometimes I'll have settlement conferences with pro se's, And it's important for them to come into court. Sometimes that's their day in court, you know,
Yes.
to let me hear what they have to say, and to me say, you know what, that is bad the way they treated you. That is, or whatever the case may be. And that's important. That goes a long way. And it goes a long way towards resolving disputes and helping them resolve disputes. But now they're sitting in court and they felt like they got a day in court. So
Um, yeah. Before I have one or two questions
yeah,
where I'll sort of, draw on your experience and expertise truly,
yeah,
as it relates to sort of civil procedure things. But before we go there, since we brought up, Judge Spatt, is there anything you specifically do, whether it's how you conduct a pretrial conference or how you preside over jury selection, or I'm just curious, is there something really sort of tangible or specific where he's really sort of informed or influenced very specifically what you do? I know that
yeah,
we've talked about his presence, quite
yeah.
literally, to even today.
I think that's a good question. I think there were two things that I think about him often when I'm doing them. Settlement conferences, I use phrases he used to kick
Uh-huh.
off, like, nobody leaves here a winner. It's, a settlement is a compromise, and as a result, a good settlement means both sides are a little bit unhappy. And that sort of sets the tone. But definitely in settlement conferences, how we did them, and then I think more importantly, just how you are on the bench with the litigants. Like, I don't raise my voice. I don't. If I have to raise my voice, I've lost control, and that's not good. So I don't. I just don't. And he never did. And the way he did it, I used to watch him with oral arguments. If you were sitting in the audience, the way he would ask questions of both sides back and forth, and you wouldn't have a clue walking away from that oral argument how he was thinking or feeling. Like, it wasn't like one-sided. I think both sides had to have walked out of oral arguments feeling like, okay, this guy understands it. He's focusing on the right things, and I can't tell where he's going.
Mhm.
And that's what I try to do. If when I do conduct oral arguments, I do exactly the same thing. I may have tough questions for the plaintiff and for the defendant without sort of indicating, because I don't want to give the other side, sort of muscles. Do you know what I mean? Like, I try to be that sort of even with arguments, and that's what he was really good at. So that is
Yeah. Yeah,
definitely.
and I have to say that is, as you well know from your experience, not every judge sees it that way or
I
does it
agree.
that
I
way.
agree. I just like the way but he did, and that's the way I like it to be.
Mhm.
And I liked it as a lawyer that way too. I didn't like it if I was getting hammered in front of my adversary. You know what I mean? No, I let, the decision will come out and somebody's going to win, somebody's going to lose. But in the argument, let's have a discussion. That's how I start out arguments. Like, let's have a discussion. I want to have a discussion about the issues. Here's a couple of things that I'm thinking about. And I really try to make it comfortable for the lawyers that it is legal discussion. It's not argument. I mean, it's a legal discussion.
Um, yeah, no, this again, and this sounds familiar to me. Again, from the experience that I had as a law clerk for the judge who I worked for, or
Yep.
clerked for, that in particular, and this again, the next question really comes out of that same experience,
Yeah.
um, which was he really, really didn't like resolving discovery disputes, and which is like, well, who does? But it was
I was going to say that.
very particularized or very specific, because he said, how can I possibly know? Which is, I
Yeah.
don't know the context. I mean,
Right.
they're showing me these pages from a deposition,
Yep.
but I'm seeing a snapshot or a moment. I
Yep.
you know how and he really sort of felt like, I understand that there has to be a decision made and it's a discretionary judgment. So he wasn't worried about, like being reversed or anything like that. It
Yeah.
was just he found them frustrating. So the question is, and this is really sort of aimed at whether
Yeah.
it's for students or lawyers, what and this draws also on your experience, practicing.
Yeah.
What are your thoughts on how to navigate discovery disputes? Um, and I'll leave it. I'll sort of ask that as that question because it's sort of broader than how do you litigate them. I think there's a
Yeah.
sort
Yeah.
of antecedent set of developments that take you to that point.
I think you have to, I mean, listen, you hear this in seminar after seminar. Know your judge, know your court, know the rules. There were local rules and how to raise disputes, things like that. But more importantly, it's know your judge. I mean, I've written a lot on discovery disputes, as most of the MJs and DJs have here. You get a pretty good sense of where I'm going to come out on certain issues. I think if you really pull those together. So if you're working on a case, I'm assigned to it, or different MJs assigned to it, it behooves you to really understand their thinking on discovery disputes. And you pick your battles. I mean, I remember, that was my view when I was in practice. I mean, could I fight over every piece of discovery? Of course you could. Could I object to every deposition question? Because most lawyers don't ask great deposition questions. Yeah, of course I could. But you pick your battles. It gives you more credibility as a lawyer, that you're not fighting. And it's funny, I see it now on the bench. There are certain firms or lawyers that may appear, and I'm like, okay, this will be interesting. We're going to have a lot of discovery motions here. And, so you do get reputations in the court. I can tell you that. Some cases I'll have the initial conference and I won't see them till the final pretrial conference. And they've worked out everything between. Other cases, initial conference, if it's certain lawyers, I know there's going to be a lot of motion practice. It's just the nature of, I guess, who they are or how they practice. Not that it's frivolous, but rather than work things out, they're scrappy and, are willing to fight every issue. So that's what I would say, is sort of get to know the court you're in, the judge you're before, how they're going to react to this stuff. But, more and more, more often than not, it's flexibility. It's approaching it with flexibility. You don't have to win every battle. I think sometimes lawyers lose sight of the fact that it's the war that you've got to win, and you're going to, through the course of pretrial, you are going to win some battles and lose some battles, but you got to keep your eye on the ball here. And the ball is the war, the end. And that's what you got to win. So sometimes that means you don't fight certain fights. I would just say to lawyers, you do get reputations pretty quickly out there. That's for sure. For one who's going to be, and even in practice, I knew that. Like, I would get a case, for example, and if a client's trying to get a sense for budgeting or for time frame, how long is it going to take? What's it going to cost me? And it sort of depends who the adversary is. Sometimes you get an adversary, if somebody stepped in and I've had cases against him or her, I could give you a pretty good gauge. This will go smoothly. We'll get through it. But, somebody else may step in. I say, you know what? Every time I've had a case with this person, there's been motion after motion after motion. So brace yourself. And yeah.
Yeah. And then, of course, the timing of your appointment or confirmation during the pandemic, something that we all live with now far more than we did.
Yep.
The Zoom technology and that piece. And just curious about, and even going back to your experience in private practice, how has, just the sort of general question of, technology and civil litigation, how has it changed? Is it making, one view was, oh, now everything can be more protracted and expensive. I don't think that's what people want.
Yeah.
But the hope was, oh, maybe this could actually reduce expenses. What's your thoughts on that sort of set of questions?
When I started practicing, Roger, email was just starting to be used commercially. There were faxes, a lot more letters. There were typists who would type briefs. It was rare for associates to have cell phones. There was no remote. Nobody even thought of that. In fact, I had a case when I first started White and Case, and I had a partner that I worked with. Our adversary was never getting back to us, never acknowledging letters we sent, things like that. Finally, the partner says to me, "You know what? Send him a telegram." Telegram. So we sent the guy a telegram. He picked up the phone immediately and said, "What the hell are you sending me a telegram for?" Well, it got your attention. That's why. but I mean, people today wouldn't even know what a telegram is. But listen, technology is great, and I've seen it develop over the years that I practice and now on the bench. You know, I mean, remote, we all are feeling that now, but I mean, electronic presentation of electronic evidence, you know, ESI, the storage of information. But I think what's the big thing now, of course, is AI, and it is like lightning speed going to change the practice of law. You know, I'm on the New York State Judicial Institute of Professionalism, and we're starting to study that right now. I mean, you know, we all saw the case that Judge Castell had this past summer about the lawyers submitting the AI brief that didn't have good citations. So, I mean, that's just one issue, but many big firms now are investing millions to develop in-house AI systems. What does that mean? They're going to be writing briefs. They're going to be preparing outlines for direct exams, outlines for depositions. You know, it's going to change the role of lawyers. I think that's going to be the most dramatic, and dramatic in the sense that it's going to come on fast. Like, it's here, and man, the firms are spending the money on it, and part of it is driven by clients, right? The big law firms have major clients that are using AI and asking law firms, how come you guys aren't using this? Why do I need an associate to be, you know, spending 50 hours drafting a brief when you know, AI could probably do this in about an hour? So at least an initial draft. So I
Right.
think AI is the biggest change
Yeah.
to see. And if I were coming out of law school, I'm even now I'm really trying to keep up with all that's coming out about the uses in the legal system. But you know, rule of professional conduct 1.1, comment 8, we have to, as lawyers, we're obligated to keep abreast of technological advancements and developments that help in the practice of law. We're obligated to. So those are the lawyers that are going to do well, that you know, embrace it and use it. And but I think that's going to be the biggest thing. And you know, a year from now, Roger, you and I can talk and say, boy, you know, I bet the role of the associates in firms is going to be much different a year from now than it is right now. That's how quick it's all evolving.
Yeah, and of course, there's, you know, the sociology of this is
Oh yeah,
is fascinating too, because of course you're talking about those who, you know, the investment made by those who can afford to do it because the clients can pay and they're corporations or
Yep.
institutions, and yet of course it'll how it ripples through for those lawyers who represent individuals.
I agree.
Is also equally uncharted as
Yeah,
or
no,
or
it
yeah.
raises access to justice questions for sure. But on the other end of the spectrum, you know, there is courts now experimenting with AI kiosks, like in landlord tenant court, that you could put in your question and generate some. So there's actually, you know, as I say, experiments going on across the country in different courts for that would actually help AI help, you know, people who cannot afford a lawyer. But I think it remains to be seen what happens with AI, but it's out there and it's going to continue to be used for sure. But
Well,
you know, and
yes.
the question there is, you know, how do junior lawyers get trained? How do they get trained as lawyers? Because, you know, fundamentally, lawyers are paid for their judgment, whether it's using AI or you know, going on Lexis or presenting argument. You used for, you know, your judgment is what you're getting paid for. So, but how do you teach lawyering then? If you know, as we move towards AI, we can't lose that one-on-one, that working collaboratively, that sort of thing.
Yeah. Well, it's a joke, but or it's going to sound flip, but I made it. I mean, I'll see
Yeah.
you in a year or two, and we'll do another one, and
I'm
we'll see what's happened.
Yeah,
Because
yeah.
yes, I mean we're wrestling.
Mhm. Yeah, no, I read one study about where they ran a question about topics for cross-exam at trial of a witness through AI, and they had a panel of, I forget, 3 or 4 top lawyers across the country independently come up with their list of areas for cross-exam for a particular witness. And wouldn't you know it, AI came up with 3 or 4 more than these lawyers did. And the lawyers didn't poo-poo it. These were top lawyers who said, wow, I didn't even think about those topics. And they're good. So there's a there's a benefit to this stuff. It's how we use it and embrace it.
Yeah. No, we're starting to talk about it at the law school, of course.
I bet.
And then, of course, there's changes to the bar exam that are coming.
That's true too.
But that may not last. In other words, the next iteration may already be outdated.
That's right.
Yeah.
But the key is, like, people, lawyers need to understand they can't do what this lawyer did this past summer. The Judge Castell sanctioned him for, and that is just use GPT, the open system, to run a question, because you got client confidence issues, things like that. The law firms that are doing it are developing in-house AI programs. So it's closed. And that now you've solved the client confidences issue, and that's the big issue. You can't just throw things in a public AI and write this brief or write this court opinion or because of confidentiality.
Well, this is really we've ended on a very interesting subject, one that we should revisit.
I'd love to.
Yeah.
Thank you for having me.
No, thank you. It's I absolutely will be sharing this with my civil procedure students next semester, because they should know. Many of them will stay in Long Island. Many of them will practice in Long Island. And this is very useful for understanding how the court works, how the federal court works, the federal courts work. So thank you.
At least the Eastern District.
Right. With that caveat. Right.
Anyway, thank you for having me, Roger. I much appreciate it.
Thank you, Judge.
All right. Take care. Have a great weekend.
You too. Thanks. Bye.